Today's webinar is entitled Intellectual Freedom, Basic Training for New Staff and a Refresher for the Rest of Us, presented by Mary Minow. Mary is a library law consultant. She worked for 10 years as a public librarian before studying law. She finds the intersection between our legal rights to free speech and library collections utterly fascinating. This webinar is partly based on materials by Catherine Lord's work, Defending Access with Confidence, a practical workshop on intellectual freedom published by the Public Library Association and available through the ALA store. I am now happy to introduce Mary Minow.
Thank you, Chuck. Today we're going to take a look at what intellectual freedom is, and then we're going to quickly move into the legal ramifications. What have the courts said in terms of intellectual freedom for books and for the internet, and we're especially going to point out what you should do if somebody's looking at child porn in your library. We're going to move on to strategies, largely based on Catherine Lord's work, and I want to remind everyone who's ever heard me before, this is legal information, not legal advice. So what is intellectual freedom? Let's take it where the rubber meets the road, where you are on the desk and a patron comes up to you and says, I want you to remove this book, for example, Daddy's Roommate. What do? It's a little different if you're in a public library than if you are, say, in a private home or even a private library. Well, let's go back and take a look to see how libraries have handled it. It's changed over the years. Back in 1876, when the American Library Association was founded, libraries tended to avoid controversial literature. The librarian was seen as a moral censor. And that's a picture, do you recognize him? That's Melville Dewey. And he said only the best books on the best subjects were to be collected. We've changed a bit since then. In fact, there's now a code of ethics for library staff, which says in part, we do not allow our personal beliefs to interfere with access to information. You know, it's really easy to defend the book that you think is okay, but what about a book that you personally find objectionable, offensive? Perhaps you find Daddy's Roommate offensive. Perhaps you find a book there's books that make the opposite point, that say that two gay dads is morally and religiously indefensible. Maybe you find that one very offensive personally. Here's a book, cookbook that shows kids how to make hamburgers, and a vegetarian librarian was very opposed to that. You may find really anything repugnant, and the question is, do you allow your personal beliefs to interfere with the patron, the public's access to information? The answer, according to the Library Code of Ethics, is no. We just go about our business of providing access to information. And when you move that into the law, what is the answer? Will the library that restricts access to information and then say it gets sued by a patron, will the library win in court? So the question that the court will look at is, what is the restriction on speech, and whether or not that restriction is justified. The default, and I have this green patron with a very big mouth, the default is that the patron, the public, has a right to free speech. The library has to make a strong justification in order to successfully defend a restriction on any speech, and let's run through that. The U.S. Constitution says that Congress shall make no law respecting establishment of religion, and or abridging the freedom of speech. So Congress shall make no law respecting an establishment of religion or abridging the freedom of speech. That has since been extended to the states and by extension to local governments. So if you are working for a local government, working in a library, then you may not restrict speech without going through a lot of hoops. So what are those hoops? Well, first of all, are you the government? if you are the government, and you may not feel like the government, I know I never used to feel like the government when I worked in a county library, in the sense that I thought of the big G government, but look at your paycheck. If it's signed by a county government official, then you are the, or something like that, you are the government. And so if you are restricting speech, the First Amendment will kick in. The First Amendment is at the very top of the legal framework. It's part of the U.S. Constitution. Underneath that is federal law, and under that is state law, and under that is local law. So your library policy is at the very bottom of this hierarchy. And the library policy has to be made consistent with all of the legal framework that's above it. So you can't make a library policy that is counter to the First Amendment of the U.S. Constitution. Where does the ALA Code of Ethics fit in? The one that we were just talking about? Well, that's a professional association's code of ethics, and it's been carefully thought out and revised and hammered out over the years, but it does not have legal force unless your local library board has adopted that, or say the Library Bill of Rights, which is aimed at the user. If that's been adopted, then that would be part of the library policy and would be legally enforceable. What does the First Amendment protect? Well, speech protected under the umbrella of the First Amendment includes not just that beautiful poetic speech, not just random controversial speech, but really for almost all speech that's violent, speech that's disgusting, speech that's profane, speech that is hateful. And I'm talking about U.S. law here. I mean, this is different in other countries. Canada, parts of Europe do not protect hate speech, but the U.S. does. It's highly protected speech. Indecent speech, when we're talking about the internet or in books, there are some exceptions if you're talking about broadcasting, but we're not talking about that here. Inappropriate speech, speech that can lead to illegal behavior is protected under the First Amendment. So all of these types of speech enjoy a very broad protection. So what happens if a library is sued? If you perhaps may have been working in libraries back in '82 or thinking about it, then you, and ever since then, you may be aware of this landmark Supreme Court case, the PICO case, Board of Education versus PICO. This was a case in which a student sued the high school library when the school board came in the middle of the night and removed books. They removed books like The Naked Ape, Go Ask Alice, Slaughterhouse-Five, Black Boy, and some others. And they removed these books because they said that they were anti-American, anti-Christian, anti-Semitic, and just plain filthy. So the question really is, who gets to decide? Does the school board get to decide what books go in the school library? They are, after all, elected by the people. And the court said no. The school board does not get to decide that if they're basing it on the ideas within. Yes, schools are in loco parentis, and they can decide completely what's in the curriculum. But in the school library, they cannot remove a book unless it is educationally unsuitable or pervasively vulgar. That was the standard that was set. They cannot remove a book just based on the ideas within. Now, including if it's anti-Semitic, that's an idea. It has to be educationally unsuitable. By that, perhaps it's not written well. It's got poor binding. That kind of thing. Now, that particular case was eventually settled because it was not a. I want to make it clear that that was not a majority opinion. How many justices are on the Supreme Court? 9. So how many justices have to join in a majority opinion to make it binding law? That would be 5. In this case, only 4 could agree on that principle. There were a number of separate opinions, and if you read the opinion in the most narrow sense, it just said that the books had to go back on the shelves, and there was a settlement that it had to go back on the shelves, but that the pervasively vulgar, educationally unsuitable was not a majority opinion. But it's still incredibly important because it's been followed by lower courts ever since, with one exception that I will get to. The Board of Education versus PICO thus stands for the principle that although the classroom curriculum is set by the school board, the school library is somewhere in between the classroom and a public library. A public library, and the Supreme Court opinion noted this, is a place of freewheeling inquiry, and that language shows up in several court opinions, that in the PICO case, the books that were pulled were in fact on display. The public library had put them on display saying, look at these books, and it generated a lot of interest in them because whenever a book is challenged or certainly banned, the interest level just skyrockets in those books. Books that may have garnered no attention suddenly become bestsellers, become long waiting lists, et cetera. Now, the public library, if that's where you work, is a place of freewheeling inquiry, and that's been made clear time and time again. The court cases tend to fall in the school category, so keeping the last slide in mind, showing that the public library is a place of freewheeling inquiry, you just know that if a court rules that a book has to go back on a school library shelf, that without a doubt, it would have to go back on a public library shelf because the public library has a greater sense of free speech rights for our users. There's no educationally suitable or pervasively vulgar standard. So let's look at the school cases because that's what we have. There's a case, Campbell versus St. Tammany Parish School Board, in which the book Voodoo and Hoodoo was removed from the shelves. And this book was a scholarly and a practical look at West African religions in the United States. And there were spells to do ill, there were love spells, and so the court used the PICO standard and said, was the removal intended to deny access to ideas? And if so, the book needed to be returned to the shelves. In 1995, a school board removed Annie on My Mind by Nancy Garden, which is a novel about a teenage lesbian relationship. And in that case, the court found that the removal was not based on educational suitability, again using the PICO standard, but it was based on the ideas, on the ideology of the book. So that book was returned to the shelf. Now, moving up to the year 2000, we have Daddy's Roommate and Heather Has Two Mommies were challenged at the city of Wichita Falls in Texas. And what happened there was that the city council had set up a process in which 300 people could sign a petition and demand that the children's book not be taken off the shelf, but be moved to the adult area. Now, was that something that could withstand legal scrutiny by the courts? Well, in this case, the court said no, patrons don't get to decide this. Some children and parents sued the library, and the result was the books were returned to the children's area. So even though they had not been removed from the library, had just been moved to an adult shelf, the court said that the children were being denied, their full and unfettered access to these books. And the court made the point that the next group may want to move children's Bibles away from kids. That that's just not the process. We go through the professional librarian's opinions on the reading level, who the book was directed to, that kind of thing, and that they do not remove the books to the adult shelves. Similarly, in 2003, there was a challenge to a policy that also did not take a book off the shelf. We're talking about Harry Potter, but restricted it. So here's a school library that allowed children to read Harry Potter, but kept it behind a desk and required parents' permission. So the school board required the child to get their parents' permission to read Harry Potter. Was that something that would be permissible under the child's free speech rights under the First Amendment? Okay, the child's not being denied access. They just have to get their parents' permission. And think about it. Parents get to decide what their kids, how their kids are raised. So this is a really interesting question. How do you think the court ruled? The court ruled that Harry Potter had to go back to the open shelves, that it was too much of a burden for the child to have to ask for their parents' permission. They'd have to go home, they'd have to ask, perhaps not all parents would give it, and that it was too much of a stigma, that a child who's seen carrying around, oh, that book that you have to get parents' permission for, that would be a stigma. So it's too much of a burden and too much of a stigma for the children. So you can see that children's First Amendment rights are actually really, really strong. And this is a case even in a school. So you know that they're even stronger in a public library setting. Now all of this starts to it was very consistent until we get to the most recent case, which is Vamos a Cuba. This was a picture book, ages 4 to 8, a big picture on each page with, about one sentence of text at the bottom. And the school board removed this book, actually the whole series, because there were parents objecting to the content. The parents said, this book says that the people of Cuba eat, work, and study like you. And their complaint was nothing could be further from the truth. People of Cuba are just surviving. They're not eating and working and studying like you. In fact, they're surviving without civil liberties. They're surviving without due process. That this book is inaccurate was the complaint. And the federal 11th Circuit, an appellate court just under the U.S. Supreme Court would be the next stop, which did not take it up. The court said that's okay to remove Vamos a Cuba because the book was inaccurate. Libraries can remove inaccurate books from their shelves. So that one is actually quite inconsistent in my view with the other books, but with the other cases. But the court said we don't need to use the Pico case. This book was inaccurate, and it was taken off the shelves. Now we move into the internet cases, and I know that's probably why most of you wanted to tune in. You've got your man, for example, could be a woman. A man more often is looking at porn on the computer. And what do you do when another patron complains? Well, I don't have a one-answer-fits-all for everybody listening in on this webinar because it's going to depend on what your local policies are. But what I am going to do is show you what the legal landscape is to make sure that you can check your policies and make sure they're not outside what the First Amendment requires and the federal law. Okay, now we've got the First Amendment, which we've been talking about, which protects all kinds, all lovely speech as well as disgusting speech. Underneath that, we've got federal law, and there's the Children's Internet Protection Act. Now, you know whether or not your library gets E-rate discounts or certain LSTA monies in which triggers the CIPA, the Children's Internet Protection Act, for your library. Those libraries, if you're a CIPA library, must block child pornography, obscenity, and material considered harmful to minors. I call these COH. The American Library Association challenged this law to the Supreme Court, saying that this was a problem not because of the COH, child pornography, obscenity, harmful minors, that was blocked, but because the filters overblock. The court, the U.S. Supreme Court, said this law is constitutional because, and this is the way I read the opinion, and I think many others have read the opinion, because an adult can ask the library to disable the filter on request and to unblock a particular site on request. adults have the legal right to ask for and receive unfiltered access to the library. So if it's overblocking, it's blocking speech outside of those 3 categories, then the adult under E-rate and any age, including a child under LSTA, can ask for an unfiltered access. Now, what am I talking about with that COH? These are 3 categories that are actually not protected under the umbrella of the First Amendment. That's why the case was upheld. And I remember it COH like cough, COH. So it's child pornography, obscenity, and material harmful to minors. So if you're a SEPA library, then you are required to try to block those categories out of the library, or images of those categories. But even if you're not a SEPA library, you may prohibit the use of those types of sites in your library. They're not protected under the umbrella of the First Amendment. And here I have a sad picture of a man with an umbrella that's not protecting anything. So those 3 categories are not protected under the First Amendment: child pornography, obscenity, and material harmful to minors. Now, what do those categories mean? Under child pornography, the federal law has definition, and it's an image of a minor engaged in sexually explicit conduct, not mere nudity. I mean, there's a lot of artistic photos of children, for example, who are nude. It's not mere nudity. It's got to be sexually explicit conduct. If it meets that criteria, and you can look at the language of the law for more detail, but if it meets that criteria, then it is toxic. You do not have a right to have it at home. You do not have a right to look at it for research purpose. So if a patron asks you to unblock a child pornography site because they're doing a paper on it, no, there's just absolutely no right to that material at all. So do not unblock it. In fact, I strongly recommend that you call the police if it's happening right now, and cyber tip line if you want to report it after the fact, or if you want to find out more about this, there's a cybertipline.com and an 800 number that you can call to report that. What's the definition of obscenity? Well, this comes from a U.S. Supreme Court case, Miller versus California, in 1973, and still the law of the land today. And it's a 3-pronged test you may have heard of. The 3 prongs are that the average person applying contemporary community standards would find, taken as a whole, that the material, and in this case we're talking about an image, appeals to the prurient interest. That means it turns someone on. In your community, it turns someone on. Second, so in addition to that, secondly, the work has to depict in a patently offensive way sexual conduct defined by state law. So then you're going to look to your state law to see what the definition of obscenity is in your state law. Now, it has to be patently offensive, and that means, according to my law professor, my First Amendment law professor, Kathleen Sullivan, it has to gross you out. So it has to turn you on in prong 1 and gross you out in prong 2. It's both of those simultaneously, plus prong 3. Prong 3 is taken as a whole. The material has to lack serious literary, artistic, political, or scientific value. So if there is something in there that has some sort of an educational value, it's a sex education manual. If it's got literary value, Lolita, I mean that completely takes it away from any kind of obscenity classification. So if there's any serious taken as a whole, if there lacks serious literary, artistic, political, or scientific value, then that would not be obscene. So there's very, very narrow category of materials that would fit in the obscenity category. And in fact, I try to keep up with tracking obscenity prosecutions for online websites, and it's sparse. I mean, it is so sparse. Extreme Associates is the poster child for that, and that's a company that would depict rape, bestiality, all this stuff together, and even they, you know, had a good run through the courts on that. But the average stuff that you're going to see, the I know it when I see it category, is not going to be obscene. Obscene is a very, very narrow category. Now we go to the broader category, and that's harmful to minors. Harmful to minors, according to the Children's Internet Protection Act, and then you can also look to your state codes, is any picture, image, graphic, or other visual depiction that taken as a whole and with respect to minors appears to the prurient interest in nudity, sex, or excretion. So it's the same three prongs essentially, but it's with respect to minors. So it has to appeal to prurient interest, it has to be patently offensive, and it has to lack serious literary, artistic, political, or scientific value as to minors. The main thing I want you to take away from there is that we're talking about sexual material only. The I know it when I see it kind of works, but we're only talking about sexual materials. And we're also not talking about mere nudity. We're not talking about guys with their shirts off. We're not, you know, and I'm not making this up. I mean, I know of you know, there was a case filed in Hawaii alleging that a patron was kicked off for looking at a website with guys with their shirts off. So it's got to be pornography, essentially. Pornography is just a dictionary word. It's not a legal term. The legal term would be harmful to minors, but it's got to be sexually explicit conduct. Now, if you do have E-rate discount or certain LSTA funds, then you are required to block or filter visual depictions of those three categories. And I have a chart on this slide showing that adults do not have the right to the child pornography or obscenity. Children do not have a right to child pornography, obscenity, or material harmful to minors. So I don't know of any filters, and you know, I check in once in a while with Lori Ayer, and any filters that are actually designed to make those kinds of distinctions, not to mention that, quite frankly, they couldn't make a distinction for the child pornography and obscenity unless they're looking through the court cases and see what's being determined to be, say, obscene, because obscenity is determined case by case by the courts. I do want to mention that if it was child pornography, you should report it, and if you're not sure, then just use that cyber tip line. Is violence harmful to minors? I mean, if you look at video games today, they have gotten extreme. Is violence legally considered harmful to minors? If you're watching the Supreme Court in 2011, you know the answer to that is no. The Supreme Court ruled in Brown versus Entertainment Merchants Association that graphic violence is not harmful to minors in that legal sense, that children have a free speech, a First Amendment right to violent speech. It's not considered harmful to minors, and that's at the top level. We're talking about the U.S. Supreme Court. So if you have a state law or a local policy that says otherwise, then you should, certainly if it's a local policy that you have control over, you should revise that, because the U.S. Supreme Court has ruled that violence is not harmful to minors. Now, in that same decision, Brown versus Entertainment Merchants Association, there was some discussion about the role of the parents, and I'm extrapolating a bit. They're talking about the government, whether or not the government can, say, make a law that would enforce a parent's prohibition. So if a parent said, let's put this in a library context, if a parent said, I don't want my child to see this violent video. I want you, the library, to put my child on a list that will make it so that they can't check that out. That might be okay, according to this recent U.S. Supreme Court decision. However, it's clearly not okay, according to this decision, for the library to say on its own, no children can look at this stuff unless they have their parents' permission. So you cannot, as a library, require that parents consent prior to allowing a child access. So think of yourself as a 11-year-old. You, the 11-year-old, have free speech rights to anything in the library except for COH, child pornography, obscenity, material harmful to minors. Material harmful to minors does not include violence. It only is material that fits those three prongs. It's basically sexual activity that doesn't have that doesn't, taken as a whole, doesn't have serious value. So sex education books, that kind of thing, would certainly not fit in that harmful to minors. And any other topic, hate speech, gambling, books that are just disrespectful to parents, and all of that is free speech that the child has a right to. You would want to look at your state law, and the National Conference of State Legislatures has put together all of the state laws that have to do with filtering, blocking, and usage policies in schools and libraries. And since I'm in California, and this is the California State Library's Info People project, I took a look at California law, and California law does require public libraries that get state funds, which is, most libraries, to adopt a policy regarding internet access by minors. It doesn't tell what that policy has to say, but there has to be a policy, and the idea is that the library has to have given this some thought, has had community input, and that there's a policy that's written that the public has a right to see what the policy is, but the library can make its own policy. I want to add that the library's policy cannot restrict more speech than the First Amendment would allow you to restrict. Now, we had something unusual in California in that in really all the other states that I'm aware of, the First Amendment only applies to public institutions. But in California, there's a state law in the Education Code that gives students the free speech rights in private colleges and high schools the same as they would have in a public college or high school. So that's something that that California librarians who are working in a private institution need to know, that actually the free speech rights do apply to their users as well. And there was a court case, 2009, against a community college, where a student was detained after he was using MySpace in the library. And the library's internet policy was that the use of the internet was for appropriate academic, professional, and institutional purposes. The student sued, and the student won. The court said that that policy was overbroad, that the use of the word appropriate, was too limiting. The college revised its policy to say educational purposes by students, and apparently that is permissible, to say you can only use our resources for educational purposes. We are a college after all, but to say appropriate academic purposes was too prohibiting. What about those hate sites? We do have a court case against a library in Missouri in which the library, actually it's more than one library, was filtering hate sites and was sued by a group that was filtered. And it didn't come to a court decision, but there was a consent judgment that resulted in the library removing the filters on hate speech. So hate speech is fully protected speech in the United States. Now we get to the question as to whether or not a library must disable a filter on request. And this is a case that's going on right now in the state of Washington. The Second Amendment Foundation and others have sued a library in rural Washington state. Originally, the library blocked websites certain websites dealing with drugs, criminal skills, extreme category, gambling, hate speech. They no longer do that, but they still won't disable on request, or that's the question, will they or won't they? How quickly will they do that? The Washington Supreme Court was had a question certified to it, so as to under the state constitution. The Washington Supreme Court's ruling is that actually this is very counter to everything I've been saying so far. It's the Washington Supreme Court saying, well, actually, this is a collection development decision. There is no need to disable the filters. The case continues, however. It is now in federal court. It's Bradburn versus North Central Regional Library District, and I have a URL where you can follow all of the court filings if you want, and there's even an RSS feed so that you can get them to come to you when there's a new updated court filing. So we'll just have to wait and see on that one, because the U.S. Supreme Court, the way I read it, said that the reason that the CIPA, the Children's Internet Protection Act, was constitutional was because the adult had the right to get the filters unblocked or even disabled on request. I wrote a paper on that, examining each of the justices' opinions and it can show you how I come to that conclusion. But even in that opinion, it said we'll have to wait for the next case to see how it's applied. So this would be an as-applied case. We have actually a number of cases going on right now. There's a case going on against a school, PFLAG, the Parents, Families, and Friends of Lesbians and Gays, have filed a lawsuit against a school that filters pro-gay sites and does not filter anti-gay sites. So they're claiming that it's viewpoint discrimination, which is the toughest hurdle for a government to overcome when it's restricting speech. Viewpoint discrimination triggers what's called strict scrutiny review, which means it's really almost impossible for the government to, even a school, to justify that restriction. But we'll have to wait and see how that ruling turns out. Also in federal court is the hostile work environment issue. There are library employees that have claimed a hostile work environment when there's porn on the computers. But there's also in the complaint, there's also complaints of aggressive sexual comments and touching, which is really quite different from merely looking at something on a screen. As you no doubt know from your library sexual harassment, hostile work environment training, these things are these issues are very case specific. The court would look to see what's going on, how pervasive and severe it is, and it's a very high standard. But if in fact it's severe and pervasive, we'll have to wait and see what the rulings would be on that. But it's a possibility if it's severe and pervasive, and it's say directed at the librarian based on that librarian's sex. It's a very high standard to meet, and it's a very difficult position for library directors. And I've said this, since the internet came into libraries, that the library director is really between a rock and a hard place, because they have to respect the free speech rights of their users, but they also have to respect the non-hostile work environment for their employees. So it's a really tough one. I know some libraries have dealt with it by making sure that if there's a sensitive employee, that there's always someone else that they can call on to help a patron who's working with materials that they find repugnant. So let's move into strategy, and this is where I recommend Catherine Lord's book, Defending Access with Confidence, a practical workshop in intellectual freedom, and it's published by the American Library Association. And these next slides are largely based on her work. But I did make some changes. So if there's changes or additions, et cetera. So if there's something that you don't like, then assume that blame me. So Catherine does point to the American Library Association documents that you might take a look at, the ALA Library Bill of Rights. That Bill of Rights has a number of interpretations that have been made over the years as new issues have popped up. There's the freedom to read statement, freedom to view statement, the ALA Code of Ethics, and the ALA interpretation of privacy. Then you want to look at your own libraries, mission statement, statements of library principles or values, and vision statement. Those are things that are really important. In fact, legally that's important, because if your policies don't reflect your mission statement, then they're less likely to be upheld by a court. So if let's say your mission statement is free and open access to everybody, and then you have these policies that restrict it, the court will look to your mission statement to see whether or not you've made reasonable restrictions based on your mission statement. Reasonable behavior restrictions. If you're actually restricting speech, it would be a higher standard. The next thing you want to put your hands on would be your policies for material selection, internet and database policies, the ALA Bill of Rights interpretations that maybe have been specifically adopted by your library. That's because those would be legally binding. Your collection maintenance and weeding policies and procedures, and if you have a form that you give out to your users who make a complaint, a request for reconsideration, you'd want to know if you're new to the library, et cetera, whether or not you have those, where you have those. Should you give them out right away? That's something for your library to discuss, but my general advice is to sort of hold that in reserve, because most complaints will dissipate if you listen to them and give somebody a fair chance to speak. But once they commit it to writing, it solidifies more of an antagonistic relationship, and it's not something I would jump out and give somebody that form unless you're not able to resolve the complaint more informally. You can make a referral. Let's say you're on the front line and it's not your job, then you want to kick it up, and that's going to vary from library to library. I know when I worked in libraries, different libraries gave more or less autonomy to the frontline person. Or if you're emotionally hooked, that's a good time to refer the issue on up to someone else. What should you do? You should listen. Just listen and do that reflective listening where somebody makes their complaint and you repeat it back to them so that they know that you heard it. How can you have this book that is so trashy? Oh, you find that's them, then you say something like, oh, you find that the library has a book that you consider trashy. You know, something like that, where you're not agreeing with them, but you're just repeating it so that they know that you heard them. Ask the patron, would you like to discuss it further? And then escort them or take their name and phone number and tell them that someone will be contacting them, and tell them who. Know your library's policies, procedures, and forms. I was just talking with Stanley right before this started. I mean, you never know when a situation is going to come up, and you don't want to be shooting from the hip. At that point, you want to already know what your library's policy is. Is it a written policy? What's your policy? What's your procedure for handling complaints? Do you know where the reconsideration forms are located and when to use them? And do you fully understand all of the policies at your library that affect access? So let's say a kid gets his hands on Playboy, are you going to say, oh, how did that happen? Let's make sure that doesn't happen. You want to know what your policy is before you start taking action on that. If your policy is to have open access for everyone of all ages, then that's what the policy is. Remain calm. Take a breath. You know, what do you feel like doing when you're faced with a challenge? See if you can just, do a calming breath or two. Do you want to fight, or do you want to flight? Do you want to make flight? There is an alternative. Okay, those are the first two things that you're going to probably want to do. You're going to want to fight, or you're going to want to flight. But there's an alternative. Step back, breathe deeply. Remember that it's not about me. And remember, it's not about the person who's making the challenge. Actively listen. So let's take a look at that. Step back and breathe. Visualize an out-of-body experience. I have a beautiful lavender background here. You can smell the lavender. Step outside of yourself and remember to breathe. Because really, truthfully, it's not about you. It has nothing to do with you. Somebody's upset, just like it happens with a variety of situations in a library. It's not about you. But also remember, it's not about the person making the challenge. Refrain from judgment. Appreciate that diversity of opinion is what libraries stand for. So not everybody's going to look at materials the same way. Include patron opinions. Maybe it's an opportunity for more collection development. Libraries can get kind of lopsided sometimes in what kinds of books they have. I know of libraries that had a lot of books that were anti the Bush administration. They didn't have hardly any, if any, that were in favor of the Bush administration. You want to have a mix of books. Actively listen. So signs of active listening are eye contact, an attentive posture. You paraphrase. You say back to them what they were saying to you for paraphrase for clarity. You show empathy. And to actively listen, put your own thoughts aside and actually care what the other person has to say. It really may be an opportunity for the library to seriously consider some collection development opportunities, because libraries, it depends on your community, but say a library is in a liberal community, the librarians may be liberal, they may not be including enough of the conservative opinions, or vice versa. So to satisfy the unhappy customer, and to turn I can't into I can, look at some of these examples from Catherine Lord. I can't limit your son to G-rated videos, but I can show you a great resource to help you and your son find age-appropriate videos. So have some parental guidance. So we have a variety of parental guidance resources so that they can pick the one that fits their values. Ask the customer what they want. Can you tell me what you'd like me to do? Offer something. May I try to find a book that's better suited to your taste? And be willing to say, I'm sorry. Not I'm sorry that we have the book, but I'm really sorry it turned out that way for you. Responding to challenges, strategy, and practice. Take the weight off of your shoulders. Remember the detachment mindset. And use techniques that are available to you to turn around an unhappy customer. And Catherine has a 5-point strategy for resolving complaints to make a heavy burden light. So here's an acronym. I love acronyms. The LIGHT strategy for resolving challenges. So you're on the desk, somebody's complaining about a book. You're thinking, oh, what am I supposed to do? Listen? Da, da, da. Okay, LIGHT, L, listen. Listen and just acknowledge their concerns. I, inquire. Would the patron like to discuss it? What would he or she like done? G, give or offer. Offer your policies. That's why it's good to know where they are and know what they are. Offer explanations. Offer referrals, on up. Offer other material to help guide the user, say to age-appropriate videos with so that's added value. And then H is help. Help the patron by stating what the library can offer. And if the patron is interested, sort of, if the patron really wants to pursue this, provide that challenge for them. So you do want to help them. And then T is thank. Thank the patron for caring enough. That's a very good point that Catherine's making to express his or her own free speech. So like listen, inquire, give, help, and thank. So thank you. And I know that there were some questions about the R-rated videos, so I'm going to go ahead and take a few of those while I show you some credits, because we took some pictures from Flickr, Creative Commons licensed pictures, and here's some more credits. And I have some questions about the R-rated videos. Must a library restrict R-rated videos? I'm glad you asked that question, because the answer is absolutely no. In fact, the library should not, as a policy, restrict R-rated videos. There haven't been any court cases that I'm aware of on that topic for libraries, but if a city has tried to restrict R-rated videos for kids, that's been challenged because the government cannot enforce restrictions beyond those COH categories, and R-rated videos, my goodness, those are not, most of them, if not all of them, would not meet that COH standard. So children have a First Amendment right to them. Now you might ask yourself, well, what about the movie theater down the road that won't let my child in? The answer to that is a private enterprise, and the MPAA will stop distributing films to theaters that don't enforce the MPAA ratings. So there's a huge incentive for them, and perhaps there's other reasons that they want to do. Maybe they agree that that these ratings should be enforced. That's fine. They're private companies. They are not the government. So that's the difference. You are the government. And so here's a question. So is the Supreme Court saying that it is up to librarians to prevent kids from checking out R-rated movies if the parents request this? And the answer to that is no, it's not up to the librarians to prevent kids from checking out R-rated videos, even if the parent requests this. And what this new opinion, this violent video game opinion, says is that possibly the library could have a policy that would make it possible for the library to enforce an individual parent's wishes. They absolutely cannot, on their own, have a policy that restricts the videos. But if a parent says, "I want to restrict this for my child," that could possibly pass First Amendment scrutiny. And someone asked about whether or not they can stop somebody from looking at an internet site because it's offending other people. And that's classic right to free speech. You have the right to look at something even if it's offending someone. It's that COH, child pornography, obscenity, and harmful to minors, that's at issue. But beyond that, the person who is offended, according to the U.S. Supreme Court under Cone v. California, should avert their eyes, essentially. And, here's someone, Marcy says, in my experience, customers just want to be heard and listened to. A civil discussion can be calming. I agree with that. That's very wise. And here's a tough question. When computers are in the same spot as Lois, adults and children are within seeing distance of each computer. How do you deal with the adult websites? Well, there you're going to want to look at your own library and your state law. Most, not all, but almost all states have a harmful to minors state law that generally will prohibit an adult from displaying harmful matters to children. Usually there's an intentional component because it's criminal law. So some libraries will say, look, no child pornography, no obscenity, no material harmful to minors. I would recommend using that language or saying no illegal sites, something like that. So that's one way to deal with it. If the children are not within seeing distance, then that would be a tougher call. However, we do have this Washington State Supreme Court opinion that, at least for the state of Washington, that it's a collection development decision, which gives the library an enormous amount of latitude as to what to block or not block. But as I say, that case is still pending because now it's back in federal court. And let's see. Here's Amy says an adult card is required in order to check out anything other than a G-rated DVD. Well, that's a problem. That's a problem that, let's just say, you could get challenged. There could be a child with sympathetic parents that file a lawsuit against the library, and that would be an interesting thing for us all to see how that turns out. My prediction, you never know because of the courts, but who's sitting on the courts, but following First Amendment jurisprudence, my prediction would be that children do have a right to other than G-rated DVDs, and that the child would win on that. And is there a distinction between may lead to illegal behavior and actually advocating illegal behavior? Yeah, yes. The standard that is not protected, you know, you can't cry fire in a crowded theater. You can't say, let's burn down the library and here's the torches. So if that speech is actually not protected, it's not something that's going to be on the internet, so it didn't come up earlier. But if somebody's speaking in the library, then that would not be protected if they're actually telling people, let's burn down the library. But if they're just saying, I think maybe someday we should burn down the library, that's not, that's protected speech. It's just when they're imminent danger, that it would be unprotected. So the example I give is NAMBLA, the North American Man-Boy Love Association, was meeting at one of the branches of the San Francisco Library, and certainly what they were advocating was not legal behavior, because it's about releasing the inner sexuality of little boys. But the speech itself is protected. So it would only be if they were to leave the room, walk into the children's room, start soliciting the boys. That would not be legal speech. But just talking about it in their own room is legal. And in fact, I'm talking about it with you right now. So I mean, you can see why there's such strong speech protections, because it's very slippery. If you start prohibiting speech, then where do you draw the line? Would that mean that we couldn't talk about it right now? Here's somebody, Amy, who says, due to the high fines on DVDs, we require parental permission for kids to check out all DVDs. We don't base it on the rating, just on the fact that the fines are high. Now, that's something that that would probably be permissible under First Amendment, because you're not basing it on the content, you're basing it on fines and the fact that children don't have the money and that they can't be held responsible financially until they're 18 or emancipated. So you're saying completely independent of the content, 100% based on the money, that you require parents. So that would likely be okay. You could argue that it's restricting speech, but it's based on the financial considerations. Our library limits checking out movies to 18 years and older. Parents can give limited video privileges to their kids for TV and documentary videos. Well, that's from Susan. The question is, are you doing that based on the money or on the content? In fact, if you're only allowing parents to give privileges to certain documentaries, et cetera, then that's clearly not based on the money. In fact, documentary videos are more expensive usually than the feature videos. So I would stick with limiting based on all content, not just selected content. Or I think you're safest if you just allow the kids to have whatever they want, because the conservative way to go when we're making speech restrictions is not to make the restrictions, to allow the free speech, because it's only when you start making the restrictions that you're invoking the First Amendment as a possible basis of a lawsuit. And Marcy says your local state library association may be a source for intellectual freedom information. Absolutely. Glad you brought that up. And Carrie asks whether or not adults have the right to access materials harmful to minors if children are present. So then you would want to look to your state law, but overall, generally, the answer is no. I mean, I looked at the California law, yet again, right before this webinar, and there has to be intent in California to display harmful matters to minors, whereas in Texas, there's a recent court case in which a man was in a library and he was displaying pornography, and there were no children that were actually walking by, but he was still held to be violating the Texas law, because in Texas law, there just has to be like a reckless disregard that there could be children walking by. There doesn't have to be a child walking by. So it's going to, I would say the answer to that depends on your state law. and the rest of them are thank you. So thank you all for the redo and for staying with us until the end of this archive.